Welcome back to the channel. Today's case is a textbook clash between second chances and hard consequences. We've got a defendant who's already in a DWI program, already completed education, decision-making, and victim impact classes, but still blew a 0.153. That's nearly double the legal limit after admitting to 10 drinks at her sister's birthday. The judge, not amused. You'll hear him wrestle with a choice. Do we go inpatient treatment right now? Revoke bond, shut it all down, or give her one last, tightly controlled chance with weekend jail, an ankle monitor scram, and stricter treatment IOP and SOP to keep her on the rails. Along the way, there's a practical wrinkle: impound fees, scheduling around school, and the system's constant do we cater or do we correct dilemma. You're about to see a judge who's fed up with leniency and a defense, scrambling to salvage an opportunity. If there's anything left to salvage, question for you as you watch: is this real rehabilitation or repeated rationalization? If you were on that bench, would you yank the bond and go inpatient immediately, or structure a last-chance contract with hard sanctions? Stick around till the end, because the judge lays down a nuclear warning. One more positive, and she loses 6 months to a year and a half of...
The state wants to do a 6-month extension for her to finish her treatment. She's had a couple of positives. I had a chat with her.
I'm not down with that. I'm not down with you just continuing to drink. You're not supposed to. That's the first damn elementary thing of this program is you don't drink. And you're continuing to do it. It's not gonna happen. You know, I mean, do we need to put her into an inpatient treatment program?
They're recommending IOP and SOP.
The cost of an inpatient, because with DWI-PTI.
Oh, I'll revoke her bond. It'll be free.
Hopefully we don't do that, Judge. Can you give her a chance to do the IOP, SOP? I had a chat with her.
You want to keep in this thing? I'm going to put you in inpatient treatment. You're going to go right now. There goes your life. 6 months minimum. And if you're good, 6 months. Right. If you're good, I'm sorry, 6 months. Otherwise, it's a year and a half.
Here's the first fork in the road: IOP, intensive outpatient program versus inpatient treatment. The judge is clearly signaling he's lost patience. The first elementary thing of this program is you don't drink, and she drank. Twice, the defense asks for IOP SOP instead of inpatient. But the judge pushes back with real consequences. Inpatient means she goes now. Likely 6 months minimum, and if she messes up, 18 months in custody. Audience question: do you think IOP is enough for someone who's already violated? Or is the judge right that only inpatient forces a reset? This is the balance courts face: proportionality versus protecting the public hand. The judge is leaning hard toward the latter.
Like eight drinks.
She said she had 10 drinks and she was celebrating her sister's birthday.
No, there's got to be some kind of sanction. No.
Judge, can we do, instead of putting her in inpatient, can we maybe take her in for the weekend and then let her out and go her with her
I'm okay with
treatment?
that. Yeah. And then at that point, I'm going to put an ankle monitor on her.
Can you let her come in? Did you drive here?
Yes.
Can we, her car is gonna get towed. Getting her
And
car out
I
of
care
impound.
because
Well, so I know this is not the court's concern. I'm saying my concern for her is that if you take her in right now, her car is gonna go to impound. Her family can take it out because they need a power of attorney. She's gonna come out with over $1,000 in fees only to get her car out. But she will come back.
we continue to cater to everybody. And, you know, I get killed all over YouTube because people say I'm so mean. I mean, are we supposed to coddle everybody? Are we supposed to coddle you for just 10 drinks when you know you're on a freaking probation? Shameful. You ought to be ashamed.
0.153. 10 drinks, celebrating her sister's birthday. On probation. That number isn't a mild slip, it's a statement about control, judgment, and risk. The judge immediately jumps to sanctions, and he's right to. The public safety implications of alcohol violations in DWI cases are real. The defense tries a surgical move: short jail over the weekend, plus release, plus scram. Why, it checks the punishment box without derailing her entire life. But here's the catch. Does a weekend in custody actually deter future violations, or does it just become a manageable penalty someone is willing to pay to keep partying?
That tells me that you either have a problem or you just don't give a shice about us. That's what that tells me, you know? And yet you still want a dismissal of this case. It doesn't work like that, you know?
I don't know if it makes a difference, but I've had her on bond for quite some time. And she's been on the program, she did her classes. If you give her a chance to come back, and if she doesn't do it, then I won't even have anything to stand on or come before you to say anything. And I don't think she will either. And being before you, I think she understands, right?
Yes.
Right? That if she does not take advantage of this opportunity, then that will be the end of that program for her.
Yeah. We're gonna have Pavel. So, you know, I'll tell you, the only way is 3 days as a condition, and she'll have to turn, do you have a license? Can you run her license, please? She'll have to do the 3 days, and then as soon as she gets out, immediately she'll get a scram.
Okay.
She'll have to pay for it because I can't pay for it, you know?
Well, since it's a contract with the state, I guess you could drive with the scram.
I want to make sure first she has a license. Okay, do you have insurance?
Yes, I do.
Okay. Hey, Pavel. Yes. I need you to please amend the contract and
This is the judge's most human moment. He's venting. Are we supposed to coddle everyone? He's feeling the YouTube heat for being mean, but his position is consistent. Probation is a privilege, not a cushion. When you blow 0.153 and admit 10 drinks, you're not just breaking a rule. You're undercutting the integrity of the entire program, disrespecting every defendant who fights hard to stay clean. This VO is where the audience needs to weigh in. Is the judge's frustration justified? Or is there still compassion to be had for someone who's trying but slipping? Drop your take below leniency or lockdown.
I don't know how, but so this is Miss Ramirez.
Okay.
She's had quite a number of blows, positive.
Okay.
We're amending to do 3 days as a condition, and then she's
PTI.
on the PTI.
Okay.
Well, and then the other issue is that if you want to put her on a scram, then we need to amend the contract to reflect scram, but allowing her to drive. Because normally the way that it works on your template contract is if she gets a scram, then automatically there's a non-driving affidavit.
Right, no.
So
We'll
that-
keep everything as is, but I want to make sure that she's not, at all times, she's not.
Now we get technical. The court crafts a hybrid sanction 3 days in custody as a condition, followed by SCRAM monitoring, plus IOP and SOP. The judge wants to verify her license and insurance, and crucially, wants the contract amended. So, she can drive with scram but cannot consume alcohol at all times, not just at blow test moments. This is behavioral containment plus verification a layered compliance net. Question: is this the perfect middle ground, or just a ticking time bomb before the next violation? And from a fairness perspective, is it right to deepen the financial burden? Scram isn't cheap after she already.
What days are your school? See, we continue to cater to people. That's all we do here. We cater. It's like,
The only way she can do the 3 days is if you revoke the block. So whenever she wants to go in, she has to come in, and then we have to revoke it, and then you have to bond reinstate it whenever you want her to get out.
I just want to make sure that from a practical perspective, we can get it done. So she, what
if you ever test positive again, you're going to lose 6 months to about 1.5 years of your life. Do you understand me? So if it'll be the best damn party, best damn beer, best damn drink, best damn smoke, whatever it is, you ever test positive again, I'm telling you, inpatient you go. Because it really tells me that you have a problem and you're incapable of stopping on your own. So we'll do it for you. That's it.
We're now deep in the logistical maze. Who takes her? When does she go? Will the sheriff accept her if it's only civil contract jail time? The defense proposes weekend custody to protect her school schedule. The judge. Back on catering, This is the constant friction point, courts trying to enforce accountability, while not destroying defendants' livelihoods or education. But if the system is too flexible, does it lose credibility? Strategically, the defense is trying to control the fallout, serve the time, reinstate bond, amend later. Smart lawyering, but it only works if the defendant actually follows through.
Okay, so I guess let's reset the case between now and what's your school schedule like?
I have class Mondays and Wednesdays, in the morning and the afternoon.
What about Thursdays?
Thursdays, no class.
What about Fridays?
No class.
Okay, so let's start on Thursday then. Okay, because that way she'll get a bed. Otherwise, she'll be sleeping on the floor. Too many people going in on Fridays. They sleep on the floor, as opposed to if you go in on a Tuesday through Thursday, you get a bed.
This is the line in the sand. You ever test positive again, you're going to lose 6 months to a year and a half of your life. That's not theater, that's the real sentencing exposure hanging over her head. The judge explicitly frames it as incapacity to stop equals will stop you for you. That's the legal system's version of an intervention take away your freedom to protect you and the public. Viewers, here's the heart of it. Is addiction a compliance problem or a treatment problem? Courts often try to be both punitive and therapeutic, but when violations stack up, punishment usually wins.
Going forward, I'm not going to do it because it's not fair that she's out drinking 10 beers or whatever, 10 drinks in one night, and it's a slap to the face and everybody else that actually complies with this thing. No way. I'm not going to do it. So, okay, we'll see you.
Final read. The court extends the program, but with teeth. 3 days in custody, SCRAM on release, IOP plus SOP, and a zero-tolerance policy. One more positive, and she's looking at 6 to 18 months gone. The judge compromises on timing, Thursday, Friday. Entry to ensure a bed and keeps the driving privileges alive under strict monitoring. Broader takeaway, this is how modern problem-solving courts operate structured mercy with measurable accountability. If she treats this like a lifeline, she might walk out clean. If not, the system will close in fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more